Hello, you're listening to Environmental Soup through the facilities of Trent Radio. And today I have a court case that I would like to discuss and how it relates to environmental law, specifically in Ontario. And the court case is called Democracy Watch vs. Canada, Attorney General 2026. And while the court case itself is not about an environmental issue, it has a huge impact on environmental law. And this is due to the unanimous ruling by the Supreme Court of Canada that there was a right to have a judicial review or an alternative. I plan on going through some of the legislation, and I have the document in front of me, the court case. I will switch my screens because I also show this on YouTube. So this is the title page. It was posted on July 30th, 2026. And on page 4 of this 53-page ruling, it says there is a constitutional guarantee of judicial review. And this court case is involving the We Charity and Justin Trudeau, the Conflict of Interest Act, and an Ethics Commissioner's report, which was challenged by Democracy Watch. And the government said that the law could not be challenged, but the Supreme Court of Canada said that it could, or it can be challenged. I won't go into the details of the We Charity because my focus is on environmental topics. But I will be talking about the Conflict of Interest Act and the Ethics Commissioner because it provides greater context and the Ethics Commissioner released a report concluding that the Prime Minister, at the time, did not contravene the Conflict of Interest Act, and this is related to the We Charity. And then there was an investigation. Well, this was as a result of an investigation under Section 44 of the Conflict of Interest Act. And Section 66 of the Conflict of Interest Act, this is federal law, prohibits judicial review of the Commissioner's decisions on questions of fact or law. That's what the the Attorney General argued that Democracy Watch lacked standing of its application because they prohibited the act. Section 66 prohibited judicial review of the Commissioner's decisions. And there was a section saying that there was an authority to review the legality of an exercise of delegated power, and that's the exclusive area of the courts assigned to the judicial branch, and that's related to sections 96 to 101 of the Constitution Act 1867. And I have the Constitution Act. Oh, I have section 66 first. And then I have... Okay, so section 66 says every order of the Conflict of Interest Act. It says every order and decision of the Commissioner is final, and shall is a significant word, not be questioned or reviewed in any court except in accordance with the Federal Courts Act on the grounds referred to in paragraph 18.1 for A, B, or E. Notice that there was no C. There's no C in this. So I went to the Federal Courts Act and I found section 18.1 and I have to go all the way to 18.1 full, and all of this is ignored because of the Act. Section 4 says the federal court may grant relief under section 3 or subsection 3 if it is satisfied that the federal board, commission, or other tribunal acted without jurisdiction, acted beyond its jurisdiction, or refused to exercise its jurisdiction. Fail to observe a principle of natural justice, procedural fairness, or other procedure that it was required by law to observe. And skipping C and D, acted or failed to act by reason of fraud or perjured evidence. And C is erred in law in making a decision or an order whether or not the error appears on the face of the record. So Democracy Watch was not allowed to challenge based on an error in law, and it was not allowed to challenge based its decisions or order on an erroneous finding of fact that it made in a perverse, or I don't know what that word means, or without regard for the material before it. So those are huge reasons why this is concerning. And that's a huge gap in law. And that is why it went to the Supreme Court in the first place. There must be an alternative remedy, and it has to be adequate in all circumstances to address the applicant's concerns. And a statutory regime can be an alternative. So that's where there might be some gray area if there's a statutory regime. Which this was a commissional. So we know that a commissional is not enough to have, is not a replacement later on in this ruling. It says political oversight of the commissional is not an adequate alternative to judicial review. And the Conflict of Interest Act explicitly said that conclusions cannot be challenged by anyone unless the commissioner's decisions is quashed following a judicial review. And saying that the Constitution protects judicial review, and that it says that there should be the law should be ruled or declared of no force in effect, which is an important consideration in law. And there was a saying, under the rule of law, all public powers must be legal, and all legal powers have limits. And that's in paragraph 1 under the introduction. And that was from D. Danzorus, The Politics of Deference, Judicial Review, and Democracy, in M. Tagold, ed. The Province of Administrative Law, 1997. 279 at paragraph 283. Then in paragraph 4, there's some questions that was asked, and it's almost been 15 minutes, so I'll start getting into some of the environmental aspects, and I will pause. Okay, maybe I didn't pause. Okay. Alright, so I'm back. And where was I? Oh, I was going to look at the Constitution Act 1867 before I go on. And I found, judicature, there's a section. I found 101. The Parliament of Canada may, notwithstanding anything in this act, from time to time provide for the Constitution, maintenance, and organization of a General Court of Appeal for Canada, and establishment of any additional courts for the better administration of the laws of Canada. And I should say that I'm not a lawyer, but I'm thinking that that's where they get the case from. And then the Governor General shall appoint judges of the Superior District and the county courts in each province. And then there was the Constitution Act of 1982. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Okay. So now I am at the Ontario Land Tribunal Act. And I will look at that. The Ontario Land Tribunal Act may be... Oh, did I highlight it? Maybe at risk of being unconstitutional, or sections of it unconstitutional, because Section 24(1) says that only questions of law can be appealed. So that sounds similar to the court case that was before us with Democracy Watch versus Canada. And then, even more so, there was no appeal from a decision of the tribunal in a consolidated hearing under Section 21. The question is the Land Tribunal different enough from an Auditor General or Commissioner that it is an adequate alternative? That would be a question for a lawyer. And then there's Section 25, no action or other proceeding shall be commenced against a current or former member of the tribunal or employee in the tribunal for any act done in good faith in the exercise or performance or intended exercise or performance of the person's powers, functions, or duties under the act, or any other act, or for any alleged neglect or default in the exercise or performance in good faith of the powers, functions, or duties under this act, or any other act. And the tribunal has a lot of environmental decisions, and that would be and if decisions by the tribunal could be challenged, that would change a lot of environmental law in Ontario, especially regarding the planning decisions. And let's see. But that is not clear, is not as clear as some of the other cases. Then there's Bill 5, which has passed. And then I'm thinking of the special economic zones. And then I made some highlights. So I did highlight in the Schedule 2 Endangered Species Act changes, amendments made to remove the ability of enforcement officers to issue stop orders and authorize provincial officers to issue conservation orders and to authorize the minister to issue mitigation orders. I don't know if that's I think that would be subject to judicial review. I think that's one of the weaker arguments. But the Special Economic Zones Act says the Lieutenant Governor and Council is authorized to make regulations exempting a trusted proponent or designated product from the requirements under the Act, regulation, or other instrument under the Act, including bylaws for municipality or local board, as those requirements would apply in a special economic zone. And it says certain causes of action are extinguished. Did I highlight? And then there's an extinguishment of causes of action, so that's like legal cases. And I don't know if I highlighted anything else in this. But I did highlight the special economic zones. And and it says there was an exemption of a trusted proponent or a designated product from requirements under the provisions of an act or regulation or other instrument under an act subject to conditions specified in the regulations. Other instrument in subsection 1 includes a bylaw or other instrument of a municipality or local board. So that might be a way that the government is trying to block judicial review. It goes further. And then it does define like who is a what it means by trusted proponent. And then there's an extinguishment of cause of action. So people can't take legal action in section 7.1. No cause of action arises against a person set out in subsection 2 as a direct or indirect result of an enactment, amendment, or repeal of any provision of this act, the making, amendment, or revocation of any provision or of a regulation under this act, or anything done or not done in accordance with this act or regulation under this act. So that's blocking, in my opinion, judicial review. And that includes the Crown, so the government, or a municipality or local board. And then proceedings of board. And then those regulation 373 -25. Trusted proponents. all identified as any of the following: the Crown and the Right of Ontario, the Crown Agency within the meaning of the Crown Liability and Proceedings Act, a municipality, a corporation. Did I just... Was that just a special economic... Oh, maybe that's just repeated. Okay. Rebuilding Ontario Place Act, that has a lot of environmental implications. I found non-application provincial policy statements, etc. Despite any other act, an order made under Section 506 need not be consistent with any policy statement issued under subsection 3(1) of the Planning Act, and need not to conform with any provincial plan in effect in the area in which the order applies. I'm not so sure that this the Democracy Watch would apply here, but I'm making the argument that exempting exempting broad range of laws might be a way to exempt for the province to exempt itself from judicial review if they don't have to follow any policy statements. And they're also exempt from the Environmental Assessment Act. And then there's an argument about making itself exempt from the Environmental Bill of Rights. That will be a question for a lawyer as well. Especially public consultation. If you don't have consultation, then how are people going to know enough to take legal action? As an example. There's some other ones. The Environmental Bill of Rights, I think I made a highlight at the bottom. There's protection from liability. Several laws have this. No causal action arises, no proceedings may be brought, and no remedy is available or damages, cost, or compensation payable in connection with any amendment made by Schedule 15 to the Restoring Trust, Transparency, and Accountability Act, to this act, or anything done or not done in accordance with those amendments. And then they eliminated a lot of existing cases potentially, and then it's 55(2) and 55(3). Any proceedings referred to in subsection 1 commence before the day the subsection comes into force is deemed to have been dismissed without cost on that day. So that's an clear example. And then I might get one more. Proceedings are bold in the Cap and Trade Cancellation Act 2018. And those immunity, a lot of laws have that. COVID-19 Economic Recovery Act, I think that has the same thing. But the main point is that a lot of environmental laws are shielded from judicial review, which is unconstitutional based on the new ruling. And I have to go through a lot of the legislation and I was able to look up shall be final and quotation marks on the e-law website or specific terms, and I found 13 and then there's a Democracy Watch has a website that you can check out. And then I also looked up proceedings bald and e-laws, Ontario e-laws, and I found 79 highlights of that. Yeah, I thank you for listening, and I hope that you have a good rest of your day. I also did find a lot of information from Ontario Nature about past legislation in the Doug Ford era since 2018. Ontario Nature has a document called Track Changes, the Decline of Ontario's Legal Protections for Nature since 2018. Yes. So that is what I have for today, or all the time I have for today. I hope that your week goes well, and that that some of these changes are some of these laws are challenged, so that everything remains constitutional, and that those judicial review allowed in a lot of the environmental laws. Yeah, well, thank you for listening, and I hope that you enjoy the rest of your day.